Hear ye, hear ye.
I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Jury podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just look to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello, jurors, and hello, Peter. Thank you for joining us. For those, I'm pretty sure most of you know who Peter is lawyer, and what I love about your channel is that you kind of do the opposite of me. So I come at everything from a juror perspective, like a non-legal perspective, and I obsess over details and break things down. But when it comes to the legal part of it, I'm just a regular person and don't know that part of it. So I love watching your recaps and hearing the legal perspective on things. And this case in particular, because this has been one of those that every time something happens, I'm like, this can't be normal. This can't be a normal legal thing. And so I like to watch your breakdowns of everything and see if I'm just really crazy or if it's really not normal.
No, yeah, I appreciate it. And I love your name. The 13th Juror is such a good name. And I've told the story, like my dad and I have tried cases and we've talked, and once in a while, not always, we'll have a case where one lawyer will just sit there at the table the whole time, watching the trial, not asking any questions, not handling any evidence, not doing jury selection. And then they'll handle the closing argument. And they'll say, I was just sitting over there this whole trial and here's what I saw. And so they're basically the 13th juror watching, and they explain to the jury, like there's some unbiased person at the table, which of course is not necessarily how it is, but that's how the argument goes. And it's a cool name. I like it. Yeah.
Thank you. I love that. I want to get into a lot of the Karen Read stuff, but I have a couple of other questions first before we get into all of that madness. So I know that you're an attorney, and I have to ask, have you had any cases that you've done yourself where you were like, oh, this would be so good for YouTube. This is so crazy or so weird or so different.
Yes, we have had a couple like that. I'm trying to think. We've definitely had a few like that didn't end up getting to trial on the civil side, where we've had some cases where in Florida, you have to amend to add punitive damages when the actions of a company or corporation are so bad. And we've had a couple of those cases where we've amended. You have a whole hearing. You have to get evidence before you can actually ask a judge for that. And the judge has allowed us to seek punitives. Usually that's when a case settles, because the numbers can go up from there, obviously, depending on how bad the action is. So we've had a couple of those cases that have just been horrible. Unfortunately, on the civil side, it's horrible for my client. So most of them wouldn't want their business out on YouTube. Sometimes it would help because companies don't like the negative publicity. We've had a couple criminal cases as well that would be good for YouTube, that people would hate our clients. Sometimes our clients, deserve what they got. Sometimes we're able to work out deals. And sometimes it really was much ado about nothing and they've got the wrong person. We've had a couple cases where we had a guy that had the same exact name working for a big company that everybody will have heard of here. And they never told us of the second employee that had the same name. It was like a John Smith type of name, but they never told us. And it ended up being that guy, not our guy. After 2 years, he lost his job, lost 7 figures of income in attorney's fees. And it is just brutal. And they ended up dropping the case, thank God. But there are cases like that happen all the time. It's horrible. There are a million different ways. We've had cases where we've sued private people who have made complaints to law enforcement, got our client arrested, and we found out what's in the arrest affidavit is wrong, but it's not the cops' fault. The people are lying to the cops, and the cops took it at face value. And the cops were not happy when they found out about those lies, but that didn't stop our client from being in jail for a couple weeks and having her life ruined as well. So yeah, there's a lot of cases, unfortunately, out there that are horrible and that YouTube would find interesting, but they don't make their way on there for one reason or another.
Yeah. Do you okay, so when you say that there are certain clients that that everybody would hate, or people who have deserved what they got, how is that? Because I know one of the things about defense attorneys is defense attorneys can get a bad rap, because there are some, and I've made some of them myself on this channel. I've made fun of some of them myself, so I'll admit that. But there are some that will get a bad rap for the way that they do things, or because of their clients. So how do you, when you have those that are guilty and those that are not likable, how do you approach defending that? Like, because I know you're not defending what they did. I know that's
well, you hold the state to their burden, right? You make sure that they did everything right. You make sure they didn't violate anybody's rights. So I'll give you kind of two examples, and I always have to be careful, of course, but all this is public. They went to trial, so everything that happened in the trial was public. But one case I truly believe was entrapment, but at the same time, if the FBI would have asked me the same questions they asked him, I never would have eventually said yes. He eventually said yes. He was didn't have the same mental capacity I have. He was in a more vulnerable position. I believe they sought him out, but the things that he did were horrible at the end of the day, and that's an affirmative defense. So we admit what he did, but the reasons why he did it, I disagree with, but people would have hated that client. And we went to trial, me and my dad together, and we lost. It's a hard-fought trial. Judge was really fair. But there were all sorts of issues. Then on the flip side, there was another case. I didn't handle it. My dad handled it. I handled some of the appellate parts of it, but went to trial, lost. We won the appeal, went to trial a second time, lost. We won the appeal. And when we were going to trial a third time, the FBI, we found out, had destroyed evidence and not told us about some evidence that existed. And the judge got mad that she reprimanded on the record this FBI agent, basically said he was a liar, and dismissed the case. And that's after juries found our client guilty. So people would have probably hated us for that, but it was the right thing to do. And if the FBI is going to do that to this guy, then they might do it to you. And if they do it when you say you didn't do it, now we've got an innocent person in prison forever. So you have to hold people to the rules. You have to hold especially law enforcement to make sure they're doing things right, or the snowball effect starts happening, and then there's no stopping it.
Right. And you mentioned your dad. I love your dad. He's the coolest. And I loved, I didn't get to see all of it this morning, but I saw the podcast. I saw part of it when I was getting ready this morning, and that you have out with your dad. So I want to see the rest of that, but he's awesome. I bet that's cool to have some of his insight too, from the federal perspective and all that.
It's literally the best. I always say this, like, you can't have his resume anymore. People that are federal judges across our circuit, across our state, the elected state attorneys in multiple jurisdictions worked for him and with him. We've had trials where the judge is like, Mr. Prosecutor, I have to let you know I did work for Mr. Tragos, how I learned to be a lawyer. He's like, okay. And he said, if it's a conflict and you want me to conflict off, that's fine. I do have to let you know the only other judge in this jurisdiction also worked for Mr. Tragos at the U.S. Attorney's Office. So you're not going to get anybody that hasn't worked for him. So we've had trials like that. But I will tell you right now, there are some people, maybe even yourself in some cases, that would hate him in some trials because he goes hard. He fights for his client. He doesn't care what people think about him. Like, it brings to mind, like, Harpootlian on Murdaugh's case. Most people hated him, but I can see some of those vibes in my dad too, where he literally doesn't care. He's going to do what's best for his client. He's going to go fight. He may lose, and he's going to continue doing his job if he loses. And so there are lawyers like that out there. My dad is one of them. I am probably one of them too, right? The people that watch my channel, I should say, like me. There's plenty of people that hate me out on the in the universe out there, especially online. But I'm sure they wouldn't like me in some criminal defense cases, my dad in some criminal defense cases specifically. I think they'd love me in every civil trial because we're fighting for the little guy, David versus Goliath, the injured party where the big corporation's trying to take advantage of them. And that's also why I love that. That's where my heart is.
Yeah. And okay, so I want to talk about that because you said that there are people out there that hate you. Have you noticed that this case has more vitriol than any of the, like, to the point where it's not, I used to joke about how when I covered the Melly trial, that the trolls were the worst in that than I've seen in any of them. If you disagree with even just one little thing, if you give an opinion or a perspective on something that's just one little thing that disagrees, with certain people, I used to joke about how Melly was the worst, and then this one started, and the Melly trials, those trolls would want to ruin your day, but these want to ruin your life. Have you noticed that this case has more, I used to call it passion, but it's kind of gone beyond that at this point, where it's no longer there's no ration rationale behind some of the stuff that's said.
Yeah, if I were to guess why this case feels different, it feels like the lawyers and the client in this case, the defense attorneys and the defendant are more embracing of it, asking for it, literally soliciting it on, YouTube channels. And I don't mean through third parties. I mean, literal interviews, Alan Jackson putting stuff out there, Yannetti, courthouse steps, and they embrace the public. They embrace the push behind them. So I think that emboldens people. I think that adds passion to it. And then of course you have some people out in the world that are pushing it as well. And then the other side, because of the third party culprit stuff, pointing the fingers, anybody that feels like they're wrongfully accused, I can understand why they come out. They're angry. They fight back. I would agree with you. This case does feel different. That would be my guess as to why. But I will say, I feel like it might be a trend. Hopefully it's not. But the Baldoni Lively case feels like it's pretty bad too. And it's not even like you can just look at a legal document, talk about something that it says, or you're sharing your opinion. Like if I was on the jury, people don't understand that. Like you're sitting on the jury and, Brooke Nellius, who's in the chat, is on the jury. You guys could see things completely differently. And guess what? You've got to work that out on the jury. Like you have to work that out. Somebody's life is on the line. But people online seem to think if you disagree with them, you now hate women if you're, on Justin Baldoni's side, or you like false accusers if you're on Blake Lively's side, or you want to protect people that hurt other people if you think Karen Reed has been done dirty in this case, or, they put you in a group. And I think politics and all that has, been trending that way as well, unfortunately, in our country. And people can't have nuance anymore. You've got to be able to have nuance. Like you can think one thing and you can be open-minded to something else, and you should be able to have those open discussions. That used to be what made America such a great place to have differences and be a melting pot where we could all come together.
Yeah. Some of my favorite discussions that I have with people are people who disagree on everything that I think. I love that because I may still disagree with you at the end of the conversation, but I love being able to understand why you think that and where you're coming from. And I wish that this would be, I feel like this could be such a great, because people are so polarized on this one, I feel like it could be such a great opportunity for us to really understand each other's perspectives. You mentioned the third party culprit thing. If you were the defense attorney in this case, would you pursue that? Because I think that some of that has ended up being like a shift of the burden of proof. It seems like in the first trial, it became either you have to believe that Karen Reed did it, or you have to believe that the Alberts and McCabe's did it. And it almost made it like it's choose A or B instead of this is another reasonable option.
Yeah, it almost became like a civil case, right? The preponderance of the evidence. Which one is more likely? Decide which one is more likely. That's your job as a jury. And frankly, most lay people, especially if you're not into true crime, you think every case is a whodunit. You come in and you got to figure out who did it. And if you just don't know, or you feel like you picked this guy, but they didn't prove it was that side, I wouldn't completely abandon the third party culprit, because I do like the idea of, well, if it wasn't Karen Reed, could it have really been anybody else? So you give them some options of it could have been them too, but you explain it very specifically. And again, the whole Karen Reed was framed, Karen Reed is innocent, like that type of argument to me does create a burden, like you said, as opposed to, we're here, members of the jury. This is so incredibly unfair to Karen Reed because of how this investigation went. It is just as likely that it was Colin Albert, Brian Albert, Brian Higgins, as it is Karen Reed. And you know what happens when we get there? It's not guilty, because it's the prosecution's burden here to prove what happened. And you know why they can't prove what happened? Because they put things in solo cups. They put them in Stop and Shop bags. They had Trooper Paul do the accident reconstruction. The ME couldn't even determine the cause of death. And then we have these experts that are going to say he wasn't even hit by a car. So how was he killed? We don't know, because they didn't figure it out. And because they didn't figure it out, we're here. And the way our justice system works is it has to be not guilty, or else whoever the cops say did it, we might as well throw them in prison. That's basically the argument I would use. But I do think that there are some people that sit in there and they're like, man, I feel bad for John O'Keefe and his family. Are we really just going to let it go? So you give them some other options potentially of who did it without them having to actually decide which one.
Yeah. If you were a prosecutor, would you prosecute this case?
No way. No way. So when I was a young prosecutor first starting out, even, right when I got there my first week, they would give me a case. It was all misdemeanors. There was nothing anywhere near as serious as this, but they would give me a case and I would go try it. I wouldn't even think about what it was. I was like, yes, I get to try a case. That's why I went to law school. I want to go to trial. And there was one case I tried, looking back on it, I shouldn't have tried it, right? It was a stupid little case, but I tried my hardest and I got that person convicted. And it's the only case I can think of when I was a prosecutor that got reversed on appeal. They appealed a misdemeanor and won because it was the total wrong cause of action. It probably wasn't even criminal conduct, but they gave me the file and I went in there and I tried it. It was like the second trial I ever had. And I had so much fun. And to me, it was all like, let's go do it. Let's go get, so I get it. I get the feeling. I'm very competitive. I want to go win. So I get it. But I like that happened to me because I can look back and actually have something in my mind. Like I shouldn't have done that. And we had another case where a ton of evidence got suppressed where other people may say you shouldn't try this case. It was a DUI. He blew a .31. Okay. And they got that suppressed because the cop did not he turned off the camera, turned it back on. The guy refused. And then he said, oh, okay. Yeah, actually I will blew a .31. So they got that suppressed. But we had him looking drunk on video. We had law enforcement. We had his driving in and out of lanes where this guy could have literally killed somebody going head on. So we went and tried the case with just the cop, convicted him. Some people may say you shouldn't try that because you didn't have enough evidence. I disagree. I think we had enough even without the blow, and we went and convicted him. And I knew in my mind he blew that .31. So it's like, even though that wasn't going to come out, that came into the equation as well.
Yeah. I think that's good that you say that, that you had that experience, and that I like that you say that, because I think that there are, and I've talked about this in my podcast before, I think that even though we're supposed to go into things with a presumption of innocence, we are kind of ingrained to go into it with the presumption of guilt because we're wanting to believe that the bad guy is on trial and we're going to be here and be a part of justice. And especially when we're seeing, I've been in the courtrooms where you see the families and how much they're suffering and how difficult this is. And I can imagine that it would be hard for a juror to see that and feel like they're, and to still feel like they're helping the defendant instead of, because I can see where that would be a mind issue.
The best things that's come from your show and people looking at, these cases with a fine tooth comb and really trying to think through it is that justice doesn't mean conviction.
Right.
I understand that feeling. And I am for victims, right? Like I 99% of my practice now is civil, representing victims. I don't do any civil defense myself. I still am on a couple, maybe criminal defense cases, ancillary, but our firm still handles criminal defense. But justice doesn't always mean convicting the person that the cops arrested. And that's the difficult part. But I think people are starting to understand that more, is justice is sometimes holding the people that did a bad investigation accountable so that they know you've got to do better next time. It's your fault. If you really believe that person's guilty, it's your fault they're going free, not the jury's, not anybody else's, not the defense attorneys. It's your fault.
Yeah. So one of the things that I was so glad that you covered recently was the Morrissey video. When I was reading the motion that right before you covered that, when I was reading the motion about how, they were like talking about tainting the jury pool and all this stuff, I kind of went like scorched the earth on that podcast episode because I was so frustrated with to me, it just seems like having seen that more, because you had not seen it before, right? Like you had, because I know you wanted to go into this not without anything, from previous stuff influencing you. So I had seen it though. And so when I saw that new motion and how dare they, you can't say this to the jury pool. And I'm like, Morrissey did exactly that. And I was so frustrated. And when you did that video, I was so glad because I liked seeing your opinion as an attorney on that, because to me, it felt so wildly inappropriate. So will you tell me your thoughts on that for anybody who didn't see you cover that part?
So one of the other things because a lot of people came back and said, I don't know about a lot of people, whatever. Some people, I like to read the comments that respectfully disagree, kind of like we were talking about. If they're like, you're an idiot, Karen Reed's team is paying you and whatever. It's like, okay, I don't even read the comment. So if you want me to read something nasty you have to say it politely and I will read it and I'll reflect. And there are people that are like, why don't you say anything when the defense comes out and says X, Y, or Z, or when they were at the courthouse steps? And my response is pretty simple. A lot of what they're doing is responding to what's publicly being put out there. A lot of what they're doing is talking about things that happen in the public, whether it's at a hearing and a filing, and that's appropriate and that's okay. Not what Morrissey did. Additionally, when you have elected or appointed district attorneys going on and saying that stuff to local groups of people, it is different. These are somebody they look to as an authority figure. You're telling them what to do. You're telling them what the truth is. You're not leaving anything open. You're using legalese in a way that is not appropriate. Like using the grand jury to make it sound like somebody's already found her guilty, right? Which is exactly what he was doing. I don't care what he says he was trying to do. That's what he's doing. And he's looking at you and he's saying, you live in this area. A grand jury of your peers already found her guilty of this. Like, what are we talking about? You're going to say it's somebody else. It was not them. So what's he doing? He's destroying defenses. He's saying she's guilty. That's prototypical what prosecutors shouldn't and can't do. And if they do it, they should be held accountable in some way, either by votes or somebody cracking down on that or looking into how they're running their office. And that's what he is, right? He is the top guy, the top prosecutor in that jurisdiction. And we may look at it in Florida or other states and be like, whatever, this guy doesn't know what he's talking about. But when you're there and you hear his accent and know he's your neighbor, basically, and he's your guy and you look to him, it's different. It's different.
Yeah. Do you think, well, first of all, okay, so Lally was very, he can be very monotone and very repetitive and sometimes hard to follow. And Brennan is very much the opposite in a lot of ways with he's very theatrical, very dramatic. They obviously have very different styles on how they present things, how they question things, but also in what they're going to be presenting. How do you think that this trial is going to be different from the last trial with Brennan being in charge now?
Yeah, I think it's going to be completely different. I said that from the jump, the first hearing we saw Brennan and, comparing him to Lally specifically. I think that he is going to run a much tighter ship. I think there's going to be a lot more objections. I think there's going to be a lot more arguments. I think he's going to try to push and get a lot more in than Lally did. Lally didn't try to use any of her out-of-court statements for any reason. I think Brennan's going to try to use a lot of that. There didn't seem to be a plan. There wasn't a beginning, middle, and end or a structure to Lally's presentation of the evidence. I think that's going to be very different. And I just kept waiting for the Commonwealth to have experts that could combat the defense's arguments or the defense's experts, and they just fell flat most of the time. I think that's going to be different this time. I think they're going to have a lot more experts. People are going to hate them. People are going to disagree with them, but they're going to put information in front of the jury and say, I am an expert. They didn't hear any of the voir dire or any of the Daubert challenges. They didn't hear any of that. The defense is going to try to discredit them as much as they can in cross-examination. But when you're thinking about lay people in a jury, we give them some grace. It's like, I'm a doctor. I'm a neurosurgeon. I, work with animals. I'm a dog specialist. So let me tell you about these dog bites. It wasn't a dog bite. That's going to make a big difference in this case than the first trial. Yeah.
And okay, so speaking of the dog bite, so when Judge Cannoni ruled on, because I saw your recap on this and you were as shocked as I was about the ruling on this one, with the dog behavioralist being able to testify about the cause of the injuries on the arm being from a dog bite, when she had specifically said that nobody that's not a medical doctor can rule on that. And also the whole thing with Dr. Russell having the 2 days worth of voir dire and the, however many pages of, well, it was a close call, but, and the Commonwealth said this and this and this that could discredit Dr. Russell, but I still allowed it. And then with how different it was with her ruling on the dog behavioralist from the Commonwealth this time, where it was just one paragraph. There was no voir dire. There was no citations of why it was allowed. Will you give me from a legal perspective, give me your thoughts on that? Because seeing it as a layman, I'm looking at this like shocked, because I didn't even think that it would be an option. I didn't even cover it much in the beginning because I was like, that's going to be an easy ruling. So I was shocked, but I'd love to hear your legal perspective on it.
So I was not at all surprised that she allowed the expert. I was very surprised in how different the orders were, like you said, and how differently she scrutinized the defense expert versus the Commonwealth expert. And that's problematic to me. That shows a problem to me more than allowing the expert. You're learning now, right, as a layperson, and I don't mean that in a condescending way at all, because I learned the same way. We all come into being a lawyer as a layperson, right? They teach you how to think in law school, but you don't know how to be a lawyer till you're in it. And I tell everybody, like especially the lawyers at my office, I'm like, hey, you're going to prep this trial with me. You are going to learn more in these 3 months than you've learned in the last 3 years, because now is when you actually get to see it in action. And you all, because you watch trials, get to see it in action. Mm-hmm. Judges let a shocking amount of people be experts. It's not really much. And my dad talked about it today. It's like you just have to show you have some special form of expertise and you can aid the jury in explaining to them something, and basically bada bing, you're an expert. It's kind of like motions to dismiss. A lot of lay people will read a complaint and be like, that's a lie, that's a lie, that's a lie. This is all going to get dismissed. And then when it doesn't get dismissed, they're like, what? It's like, because you read it as if it's true. If you're a judge, and if those lies are true, can they prove a cause of action? If the answer is yes, we get to keep going. And it's those types of things that people start to understand and see. When an expert gets struck, that's a big deal. And the judge better have a good reason and put findings on the record as to why they're striking an expert, which if this FBI, investigation guy gets struck, I think the judge's reasoning is going to be, we don't do that in Massachusetts, which I think is completely inappropriate. They do it everywhere around the country. It's a completely proper defense. It is the defense they should be running in this case. Reasonable doubt based on a bad investigation. Let me explain to the jury what a good investigation looks like, and you will understand just how bad this is, because you got all these cops getting up there being like, no big deal. We had a solo cup there, so we just scooped up the ice with it and got the blood, and no problem. We were able to do it because it was snowing. So I think that needs to happen. But so I think the problem is in the different ways in which she scrutinizes the experts and her tone and verbiage in a lot of these motions, even the motion to dismiss. She's saying Proctor did X, Y, and Z, and then she gives a little dig to the defense and no digs to the Commonwealth, who very clearly, according to the law, Proctor is the prosecution team. The prosecution team is Proctor. So you do see a little bit of that. I hate to see it. I do think she's made some good calls as well in the case, but yeah, those were not two of them.
Were you surprised that she didn't have an evidentiary hearing on the motion to? I'm not surprised that she didn't dismiss it. I wasn't surprised about that at all. But I kind of expected an evidentiary hearing only because it would be the best way to clear things up on the record for all of these questions about all of this information. Were you surprised about that or no?
No, I was not surprised she had. That motion to dismiss was never going to win. The best chance to me for them to get the just outcome, which should have been dismissing counts 1 and 3, is from the prosecutor's office. That is the point of the prosecutor. The judge cannot force you to prosecute a count. But if you have the juror notes written the way you did and the defense attorneys making the arguments they did and not making the arguments they did not, it's very difficult for an appellate court or even Judge Cannoni to dismiss those counts, or all of them, I know, with the prosecutorial misconduct, but it should have come from the prosecutor's office. I was more surprised she didn't have a Daubert hearing on the Commonwealth's dog bite expert. I was surprised there.
Yeah, me too. All right. Pilola's mom wants to know, would you allow all of the interviews and documented shows if you were the defense attorney?
No. If anything, I would talk to the media. If they do a documentary, you can talk to them in a way where you can tell them Karen's side of the story from your voice, which it's not her words, so they can't use them. So they can even put in their documents or voiceovers so you get the story across without doing that. Now, I think they did want her out there. Again, that is what's kind of different about this case, is the way they're pushing in the public. And frankly, I don't know if I've ever seen more support for a criminal defendant across the country than they're getting for her. So you could say it's working, and that's fine. I personally would not do it. I think it opens you up to a lot of potential issues.
Yeah, I agree. And that's going to be interesting too, because he's going to talk about, he said that he's wanting to use all of this to talk about conflicting statements, which I understand as a prosecutor, him wanting to do that, but also there's so many conflicting statements from all of the witnesses and the reports and all of that stuff. So it's kind of, I don't know if her statements, depending on what he shows, I guess, I don't know if it's going to be enough to, if it's going to make a difference, because there's so many on the other side as well.
I will tell you, if I was of a certain mind and I watched these interviews, I think there's plenty I could use as a prosecutor. And if I didn't have them, I think it'd be harder. In a reasonable doubt, I don't think you can prove it case. Also, I have my audience happens to lean female a little bit. It's a little heavier on the female side than the male side. I don't know why. And that's why I'm prefacing this, because some female watchers of my channel have emailed me and been like, I don't like her. I see the way she's interviewing and the way she's talking about X, Y, and Z. I don't like her. Some of them are like, I love her. She's my hero. She's a champion. She's fighting for what's right. So you have to worry about that as well, right? You're probably going to have some female jurors. And if if they have seen that, because there's a chance that somebody has seen this documentary and they could still get on the jury if they have not made up their mind, or it hasn't created any bias or lean towards them, or they lie and say they haven't seen the documentary when they have. So you open it up to people not liking her. And I also saw some people commenting on our video this morning where my dad said, you can ask this jury, what about her hair? What about her suits? And they're like people care about suits. You guys are so misogynist. It's like, if you think lawyers don't talk about that stuff, they do. It all matters. And the reason is not because we're trying to be a certain way. We know people are that way, whether they admit it or not.
Yeah.
Like if you have a minority juror, we ask all those questions. Do you think people are honest? They're not. They're not. They're not going to be honest all the time. We've got to figure out different ways to try to figure it out. And we present our clients in the most neutral way possible so that people just give them a fair shot. That's really all we want.
And that they 100% do talk about what they wear. And there's I won't name a name, but there is a person who has a very large platform who was very critical of boots that she wore or something during trial last time. So that is something that the perception of how people present themselves, or how they look, how they wear their hair, those are things that people do take it, not that it should be taken into consideration, but it is something that people do. So
I agree. And I try not to, like on my channel, we're talking about stuff publicly, say, oh, this, that. I try not to partake in that because I don't want to feed into people doing that. But I am telling you, the reality of the world is in the justice system, in trials, it matters. Just like lawyers feel like they can get a read on certain jurors that show up when one of them is in a tank top and shorts and the other one's in a suit. Do you think we're just like, those are the same types of people? They're not, because we're trying to figure out who's going to be a leader. What do they think? Are they going to take a whole jury with them? Are they a cop? Are they a lawyer? How would that affect the jury like we saw last time? All of that stuff is important and goes into the data in how we make decisions.
Yeah. Idiot One says, I feel like Brennan laid out his whole strategy. This time the defense has revealed a lot more resident their plan of attack for the Commonwealth's new strategy wisely. Do you see this as potentially throwing Brennan off his feet?
I'm assuming she's meaning come trial 2. No, I don't. And I will tell you, I joked that, I don't know if it was with my dad on this episode or another one. We always joke about, we'd love to go prosecute another case, right? We don't do a lot of special prosecutors that are defense attorneys here. I don't know if we ever do it in Florida, but that would be so fun. That would be awesome. Prosecuting a case is so much easier. Like Brennan is probably loving it. He's got all the resources. I mean, this case is a tough one. But the majority of cases you prosecute are pretty fun and pretty easy, especially when they get to the high crimes. But I don't think he's going to be thrown off. I think he has a plan. I think he is prepared. And I think what we're going to see is him hold more for rebuttal than the last case. Like the last case, I expected Lally to do a lot more rebuttal. He didn't. I think Brennan is going to try to prove what he can prove. Then the defense is going to go, and then he will respond to what the defense said in his rebuttal, which is what you're supposed to do as a prosecutor. That's the better way. And the defense can't really hold back much, right? They've already tried the case. They already gave it their best shot. Some things have been edited. They've added some experts. They're going to do an even better job this time. But the element of surprise is gone from the defense side because they have already shot one of their shots. Not to say they're not going to do a good job. I think they're going to do a great job. I think the better lawyer you are, the better you do a second time around.
Yeah. Panjiflay said Delphi juror mentioned lawyers, clothing, etc. So yeah, there you go.
We literally think about what suits we wear, what watches we wear, how we do our hair, all sorts of things, all sorts of things.
And, likability with the lawyers is a big thing too. And I can't remember what trial it was in recently when one of the attorneys said something about, if you don't like me, don't punish my client for it.
Harpootlian said that. I know he said that.
That might've been what I'm thinking. So yeah. And I do get that. Do you think that how do you think Brennan's going to come across? Because I have my opinions, but I am also no longer objective when it comes to him because he has made me so angry with some of his misrepresentations and the things that he's done. So how do you think that a jury will take him?
So he does have a voice, right? I don't like to make fun of anybody's, physical attributes, but he does have a certain kind of voice that I think some people online especially won't like. So we'll see if any jurors have like an issue with something like that. I think he's going to present well in front of the jury personally. I don't think he's going to be condescending. I don't think he is going to be doing some of the things he's doing in these hearings in front of a jury. I don't know that because I've never seen him try a case, but I've tried cases against a lot of people. And even myself, I'm very different in a heated motion hearing with the lawyer there than in front of the jury. So a lot of lawyers are very different when it comes to that. So from my perspective, I think he will be different in front of the jury. I think he'll be fine. I don't think he's going to be the most likable guy in the world. I think Yannetti is incredibly likable. I think Jackson has a personality where people could love him or hate him. Just my opinion. I think Little generally is likable. I think Alessi will generally be likable. I think Yannetti has the most layperson likable personality. That's just my gauge. I like Jackson's tone and demeanor the most. That's the type of lawyer I would want tell me what happened and tell me why you're right. Like that authoritative. I like that. There are certain people that I think don't like that, but we'll see.
And I think a lot of it too depends on how much you like the witness that they're going after too.
Yeah.
Because I've noticed that if that style works really well for me when I'm like, yeah, get them, they're lying or they're, whatever. But then if it's somebody I like, I'm like, don't mess with them. So I think that will have a big, and knowing the difference on when to be aggressive and when to back off, I think is a big deal.
You really have to. Some witnesses, ahead of time. Sometimes you don't. Dave Nizer, another lawyer at my office, tells the story all the time where he was in the middle of trial. He crushed this defense expert. Okay. It was an injury trial. He crushed this defense expert so much. Defense called us. We settled the case in the middle of trial. Jury came out and we questioned the jury. Be like, hey, what'd you like? What did you not like? And they were like, we thought you were way too mean to that defense expert. He's just up there doing his job. And this guy didn't review things, didn't proofread. His findings were wrong. They didn't care. They're like, he was doing his job. We felt like you were too mean to them. And Dave is not a mean guy at all. He's much more of a chill personality than me or my dad would be. And so we all were like, whoa. And we're glad we settled the case. Obviously it was great, but that happens. And lawyers are sometimes surprised at how jurors see things.
Yeah. Megan Easton wants to know, I agree with the perception aspect. Lastly, did you think that the Commonwealth witnesses played dumb, if you will, the first go around on purpose, saying, can you rephrase? What do you mean by that? Or half answering?
I don't know if I would say they played dumb. I think a lot of times people do that when they're trying to think of an answer, right? They'll give you something that gives them more time to think of whatever answer they want to give. I would say, and this may be giving people too much of the benefit of the doubt, I would say most of the time, if there's no conspiracy, law enforcement or prosecution witnesses, they really think they've got the right guy or gal over there, the person that did this, and they're trying to do what they can to get justice, as we said in the beginning. And so sometimes they press, sometimes they hyperbolize, sometimes they are evasive with questions. They think defense attorneys are trying to twist their words, and I don't want to give them these, this snake oil salesman, some, slick talking lawyer a chance to twist my words. So I need to make sure I say it in a certain way or don't give them too much.
Gotcha. I want to talk about ARCA for a minute. So what did you think about with the whole ARCA situation? I do agree that the defense did not turn over the stuff that they ended up turning it over in discovery after. Do you think that the deal it was as big of a deal as it was made out to be from the judge and the Commonwealth's perspective?
If I was the Commonwealth, I would have been pissed about that too. I would have filed motions. I would have told the judge, I can't trust what these guys are saying anymore because of the comments made, not during the first trial. There was no prejudice during the first trial. Everything they said at trial was true. They didn't pay him until later. And I don't believe there was a discovery violation because they turned it over prior to the discovery deadline. The one thing I take issue with, which I hate it because it was a sidebar comment, so we're not really positive. We heard them read it on the record where they said, we haven't paid them anything. And they came out and tried to characterize the question as, we mean we didn't pay them for their testimony, which actually also wasn't true. That's where I kind of took issue. It definitely felt like they were saying they hadn't paid him $1. And from my perspective as a lawyer, whether you pay him for costs, prep, or testimony, you have to disclose that because you're paying an expert. That does go to bias. So I would have been annoyed at that too as a prosecutor, but there was no prejudice. And it shouldn't have been a situation where they kick a lawyer off a case. It should not affect the second trial. If anything, the judge should say, you better not do that again. And frankly, that's all that should have happened in a situation like that. It should not have been this, oh no, are they going to lose the defense team over this issue?
Yeah. Never Enough Space, thank you for the super chat. It says, I think Dave Bell's attorney was a good example of the aggressive type of lawyer that came off too strong. Did you watch that one? Did you get to see that one?
And talked to some jurors afterwards, and they did not like him. So yeah, he had and this is the thing, I kind of have a sarcastic personality. That's kind of my humor. I really try not to do it at trial, even though sometimes I'm like, this is the perfect moment for it. Most people don't like that in a serious situation where somebody's life, liberty, are on the line. They usually don't like sarcasm. Sometimes you can tell a jury is with you. And if you want to, stretch it a little bit, but I think he was too sarcastic and too much of that with the witnesses. And yeah, the jury really did not like it. There's definitely a line that can be crossed.
Yeah. RBA says, why can't we hear what the conversation was between Karen and John on the way to 34 Fairview?
I'm not following.
What?
Is there a recorded conversation?
Not that I know of. RBA, clarify, and we'll see if we can answer. Rosa, you're both my favorite people to watch. Thank you so much. Thank you. Let's see. I had a couple of my my people who sent in some questions too that they wanted to ask. What did you think when you saw the lawyer's name being added to the defense team? Is that, I've never seen that before. I don't know of any cases that's ever happened in ever.
It's a very small percentage of cases that even have lawyers on juries. We have had one, my dad and I. But the other reason why it makes it even less likely is that we had a federal criminal jury trial that was like 5 weeks long, and this lawyer was pissed when he got picked. He ended up having to get conflicted off later in the case, but he was a civil pre-suit lawyer, didn't go to court, didn't do anything, just kind of took cases, settled cases. So we were like, that's perfect. He knows how to think about it, but he's not a trial lawyer. We never pick criminal lawyers or prosecutors or, criminal judges to be on a jury. So therefore, if none of those types of lawyers end up on the jury, how would they end up on the defense team? Like this lawyer was not, I think she was an employment lawyer, not a criminal lawyer. So how would she end up on the defense team? And then there she is.
Yeah. I think that's interesting too, because one of the things that I think is hard for us to see that as we've, I've started my podcast on this so long ago. So I've lived and breathed this case for so long that I think sometimes it's hard for me to really understand how the jury is going to be comprehending it. So I think having that insight from a juror who was there, it's kind of like the forest for the trees thing. Like I'm so in the weeds with all of the details that it's hard for me to understand what they're going to be able to perceive. So I think that's going to provide them some good insight into.
Yes and no. So yes, I agree. And if you could do it, I would do it every single time. It'd be great. But you do have to remember she's still a lawyer, right? So the people on the jury, I'm assuming, will not be lawyers. So even if she would have been on that jury, every single lawyer in that courtroom was thinking she's different. She's going to be different. She's going to control the conversation, and she's not going to be on that jury. So she will help, but she's still a lawyer, right? So it is different than, talking to a lay person that was on the jury, and you could be like, okay, how did you think about this? They'd be like, oh, I didn't even know that was the law. She's not going to have those same questions and insights to some of the things they just won't know.
That's a good point. What did you think about Brennan trying to get the conversations between Yannetti and Karen?
I think that's the problem with interviews, is you even make that a question, right? And he was never going to get all of it. It was never going to be expanded, any of that. But frankly, I think she waived attorney-client privilege to that topic at that point in that conversation. So I think that could come out at trial, her statements, what she asked her lawyer specifically, but actually getting the text messages and emails, the judge did the right thing, shutting that down quick.
Mm-hmm. But also somebody had pointed out the messages that he was wanting were from the 29th to the 3rd or whatever it was. And they took her phone on the 29th. So I'm curious as to what would have even
maybe nothing
been there anyway. Yeah, I guess so.
But if the judge would have allowed all written communication, was there an email that she sent from her computer? Did she create a program on an app and text him, and did it save that? So, I mean, it was more broad than just the text messages from her phone. I know he kept mentioning the text messages from her phone that we already have, but it was more of a broad ask than that.
Right. Were you surprised by the hung jury in the last case? Was that surprising for you?
I am always surprised by a hung jury. Maybe I shouldn't be anymore in this, new world, but it's such a small percentage of trials end in hung jury. I have, I would say maybe, I don't really know how many trials I have, maybe 40, 50, and we've had 2 hung juries. So that one on criminal case, one on a civil case, both of them ended up resolving afterwards. And so I'm always surprised when it's a hung jury. I'm always shocked that you can get unanimity, right, on these types of difficult situations, but somehow it happens. So I was very surprised at the hung jury.
Yeah. The timeline is one of the things that changed. I'm real big on timelines and all the details. And one of the things that they changed multiple times in the first trial was the time that they're saying that the alleged impact happened. And he changed it multiple times during the trial. Lally, even in the closings and the openings, it was 2 different, or not the openings, but his very first statements about it. All of that changed. One of our members wanted to know, would you focus on the timeline that the prosecution put out being 12:40? It was because they said 12:45, and then it changed to 12:30, and now it's 12:32, and they keep changing it because it seems like they don't really know. And every time more evidence comes out, they kind of alter it a little bit. And one of our members wants to know, would you focus on that if you were part of the defense team? On their inconsistencies.
Yes. So, and again, I don't know, certain judges allow you to do more with what lawyers argue and say in opening statement, especially in closing. I have written quotes, and when I do that, I'm like, okay, let me remind you what they said in opening statement so everybody knows I'm reading it, but now we have video. I might have asked the judge, or just done it, played the video of his opening where he says whatever the time was that couldn't be right based on when her phone connected to John's Wi-Fi. And then you say, why do they keep changing what's happening? Again, you go into reasonable doubt, reasonable doubt, reasonable doubt. I would focus on what they can't prove based on the timeline. I mean, in my cases now, like especially injury cases, every opening statement has a timeline, because it's like, what was life like before the accident? Here's the accident. Here's what life is like after, right? And I love a timeline for that. But I think the defense, I don't know if I would create my own timeline as much as I would pick apart the Commonwealth's timeline, but that would absolutely be a big part of the case, especially when you realize there's at least how he opened on it last time cannot be right.
Yeah. Azam says about the juror becoming a lawyer, if there are other cases, can the judge deny a juror who wants to join any party's team as their lawyer?
I can't think of a reason why. I really can't think of a reason why.
Mighty Heidi wants to know, does the lawyer, think this case should have been dismissed for extraordinary governmental misconduct?
So I think it's just within the judge's discretion. I think most judges would not have dismissed it. I really don't, because of the second trial. I think if the first trial would have ended in a guilty verdict, most judges would grant a new trial, which, because there's a second trial, it doesn't feel like a win for the defense here. That would be a humongous win that would shock the world after she got convicted if they granted a new trial because of all this. And I think most would have to, which is to say it was incredibly egregious. But because we have this second trial, the judge is saying, you've got everything you need. Here's your remedy. Let's do it again.
Yeah. Cheryl A says, Hank lies and exaggerates so much that I'm worried he's going to do that in front of the jury in opening and closing arguments. Is he allowed to do that? That's something I've noticed, that we've had trials where the attorneys on either side have said stuff that's not true, that wasn't in evidence. And, it's very rare for an objection in an opening or closing, but it does happen sometimes. But what can you tell us about that legally?
So the objection for that is facts, not evidence. If they're making an argument and that fact really isn't evidence, if they misstate facts, right? Most of the time, especially if you have a long trial, a judge will say the jury will have to rely on their own memory for what the facts are or what the witness said. Lawyers are not allowed to knowingly and intentionally lie or put forth false evidence or testimony before a jury. But to be fair to human beings who are lawyers, and I know, we are how we are, so people have certain feelings about it, but sometimes in a 6-week trial, you remember something differently from 3 weeks ago that a witness said. Additionally, there are definitely facts in this case that the two lawyers and the two sides see differently that I think some would call a lie. Others would say, no, that's how we see the evidence. That's the inference that we think is reasonable from the evidence. And that happens as well. So when it's in the gray area, it has to be pretty blatant and obvious. There's a lot of gray area, unfortunately, that the world looks at and says that's a lie, that most judges would say it's a difference of opinion.
Yeah. Megan says, do you think any new case law will come out of this case? I thought about that too, especially with how the mistrial was declared without clarifying on the charges versus counts or whatever. Do you think that, and that's just my example of what I thought maybe something that's done differently, but what do you think?
It doesn't seem like it based on the count issue that they're going to change the law. I think that's a potential chance. Now, what could be interesting is, maybe not as important to people or they don't care as much, but if she allows this investigation expert, this FBI guy, that would be potentially, the defense said they can't find another Massachusetts case that's allowed it. That could be something that's precedent setting. And that would allow defense attorneys to say, I'm citing the Reed case where that judge allowed it. Massachusetts allows it now. So does basically every other state. So we should allow this. That could be something that's precedent setting.
Right. I think with the counts thing, I think it would be more maybe how jurors or not jurors, attorneys would want to make sure that it's clarified, maybe, because that's something I don't think that I'm not an attorney. So I'm trying to think if I don't know that I would have thought in that moment to make sure that that's clarified. Because I would have assumed if they're saying that they're stuck on everything, that they're stuck on everything. I guess.
If you are a defense attorney, this is again, something that people act like is not true or get mad at or whatever. If you're a defense attorney, you're almost never pushing. They didn't convict. They don't have enough. I want to go back and now try to convince them. Like, you already tried this. I've got the public reasonable doubt. They couldn't convince this jury. So it feels like a win. The defense clearly did not push or argue for more when they came back multiple times saying hung jury. After the trial, it sure sounded and felt like a win for the defense that it was a hung jury. So defense attorneys are usually not going to push on, well, let's get clarification. Did you agree on any charge? Or maybe you should consider some lesser includeds. If they say they're hung, they're usually hung. Obviously, what we know now, if they would have pushed, potentially they would have gotten rid of 2. Prosecutors sometimes will push. And we can clarify, right rules. On the rules committees, we always ask, the first question is like, do we need this rule? Is there a problem? Or should lawyers in closing arguments do a better job of explaining exactly what a jury can do? Or should lawyers who have the opportunity to write the jury instructions to the judge, should they write better jury instructions to the judge to make sure it sets out what they can do? Or do lawyers, which does happen, sometimes leave things purposely vague?
Mm-hmm.
Do they want jurors to be confused about certain things? I think some lawyers do. So it's all a balancing effect, and hindsight being 2020. That's why we don't usually look back and change things that happened, even if we find out new information.
Yeah. Will Bev allow testimony and Commonwealth statements from the first trial? She did say this is a new trial. Normally it's kind of, they can't say during the first trial, right? It's just kind of in a previous.
Usually they'll say something like at a prior hearing in this courtroom, something like that. You were under oath. This lawyer was there. I was here. There was a court reporter taking down what you said. So we just kind of couch it as a prior hearing and not the first trial. Yeah.
Gotcha. Hey, Sleuthie. Sleuthie wants to know, Peter, do you think the defense calling Proctor in their case in chief won't be as effective since they can't be confrontational or ask leading questions? What do they have to do to have him declared hostile?
There are certain witnesses. And if I were the judge, immediately he can be a hostile witness. Yeah, as he's called, I would say he's a hostile witness, Judge. Come on. Do we have to read the text messages about what he said about me and what he said about my client? If I'm the defense attorney, he's a hostile witness. He's like the prototypical hostile witness. They should be allowed to ask leading questions. I think it would be incredibly effective if they had to call him, because then in closing, they could say, we had to call the lead investigator. And so, and the jury can surmise from that what they may. So I think it could be really effective. And that's why I think the Commonwealth is going to call him.
Now, I remember, I don't know that it's been ruled on yet. I've been kind of busy the last few days, so I haven't seen if it's been ruled on. But I know that Brennan had said that he was wanting to keep certain things out. I think one of the things he said that he didn't want the defense to be able to say that Proctor had been fired, and he didn't want them to be able to say something about the appearance of bias or whatever it was on that ruling. And it may have been ruled on it, but since
I haven't seen the ruling, but it was basically the findings of whatever that board was. He didn't want those findings to come in. I think that's going to depend on the judge. They absolutely should be able to talk about it. It's about this case. It's relevant. It's a bad investigation. And they are flat out saying he's biased. And guess what? That's one of the key characteristics of credibility that we are allowed to ask questions about as a lawyer. So the fact that this shows he's biased, to me, they should be able to get into it. Will the judge find it to be too prejudicial? I don't know.
Yeah. What about, so all of that is in this case. So I agree that I think it should be able to come in because it is so relevant. What about the, is it Anna Walsh? I don't want to get the name wrong. The other big case that he's the lead in. I know they said they are potentially not calling him. That doesn't mean the defense can't call him. Do you think that it should be allowed in that case as well? Or should it only be allowed in the case that he was dismissed for?
I don't know the facts of that case to have like a very educated opinion on it. I think they should be able to get into a lot of it, and the fact that he was fired and he has this, black mark on his resume, maybe not the specifics of this case. I don't think that would be appropriate in a separate investigation.
Yeah. Pillows One says Proctor News is all over TV, etc. How will jurors not know who he is, why he was fired? Finding a jury pool is going to be difficult this time.
It is, but you'd be shocked at how many people don't watch the news, don't know what's going on. Like, I would be willing to bet 25% of the people following this case doesn't know he's been fired, right? Not the ones that are watching every single YouTube video, but like if you're following it on the local news, you miss one episode and you don't see that he's been fired. I mean, there are people that I'm always shocked at certain cases that people that aren't watching them, aren't paying attention to them, don't know anything about them, but it does happen.
Yeah. Dawn Rawlings wants to know, why does the defense have to provide proof of another suspect? Oh, the third party culprit stuff, the legal part of the third party culprit, wanting to bring that in. She says, isn't it the defense's job to create reasonable doubt? I'm confused on this. I hope this makes sense. So she's wanting to know if you can explain like the legal reasons for having to have the proof of third party culprit.
A lot of it comes down to just fundamental fairness and justice, right? You don't want them to just say, oh, it could have been Puff Daddy, right? It's like, oh, he's a bad guy. People don't like him. We think he might have done this in this case too, because that would just confuse the jury. There's no actual reasonable belief. There's no good faith belief that happened. So you have to cross a certain bar, right? You have to have a good faith basis. There has to be some evidence that could potentially connect this person. They were there. They had a motive. They didn't like this person and they could have done it, right? Physically, whatever it is. You don't have to prove it beyond a reasonable doubt. You don't even have to have probable cause, but there is a bar before you can actually say Brandy did this. You can't just go around accusing people in trial publicly.
Yeah. RBA said she was trying to say he was trying to say it would be very important to know what was the mood between Karen and John minutes before his death.
But nobody can testify to that unless Karen testifies. Yeah,
we don't really know. None of that was recorded, and they weren't, of course, texting each other since they were in the same car. So that's one of the things that is one of the unknowns. All right, and Sleepy says, why does it's the defense's job to create reasonable doubt make me cringe?
Yeah, that's the mindset of everybody. And I have no shade to the person that asked, because I think you're getting close to the right mindset. But that's my personal friends that I've known for 25 longer now. Okay. I'm always older than I think. They sat on a jury and he's like, yeah, the defense didn't give us anything to doubt it. And I was like, that's not where you should start, dude. Like, why is that where you're starting? What did the prosecutors prove? Right? Like, that's where you need to start. And so many people start on, okay, what's the defense going to do about this? And I don't blame them, because I get it. And that's how we're kind of conditioned in the media to think. But yeah, that's secondary.
Yeah. And Wendy wants to know, I think some of the defense's arguments got lost with all of the different directions the defense went during the last trial. Bad investigation, cover up, conspiracy, etc. How can the defense tighten up their theories to make sure that the jury follows the most important arguments and evidence?
So it's not easy, right? We can sit here and we can talk about it. I can say, here's what I would do if I was the defense attorney in this case. But there's just so much, right? I would like to think, tighten it up. Just ask every question. Just ask every witness, especially law enforcement, the questions that show they didn't do their job. They didn't do what they should have done. You didn't even ask to go in the house. You didn't go in later. You didn't take measurements. You didn't record interviews, whatever. We've gone over that a million times. But you can't not talk about the connections, right? So they've got to be like, your daughter's friends with this person's daughter, and you're over this house, and you guys play baseball together, and you went to McCarthy's, and you were there at this time. It's like, you have to hit all that stuff too, right? And then it's like, you saw Karen and John together. They were lovey-dovey. You have all these different things that you do have to get out there. We all know it. So it's almost like, don't ask those questions. We already know all that. Let's get to this. But if you have to paint the entire picture for a jury, it's very difficult in a case like this, which is also why the Commonwealth wants to throw everything at you. So you have to respond to everything as defense, because you have to create reasonable doubt, right? But that's what makes it so hard, is you can't tighten it up too much as the defense, because you have to get out everything that you find to be important in this case. But your arguments should be very pointed.
Yeah. I know I told you I'd keep you for an hour, and we're at an hour. So what I want to know, final thoughts on what are your predictions for this next trial?
it's hard. It's hard to predict what's going to happen, right? In my mind, I find it hard to believe that 12 jurors are going to agree and convict her. Which is also, if we're just talking about winning and being competitive and, trying to win as a prosecutor, having 3 counts is smart. It really ups the chances that they split the baby and they come back with some guilty on a lesser included. I think that's their best chances, a lesser included on count 2 to come back guilty. I would be shocked if they won on count 1. And so, I mean, if I was going to guess, I think that's really where it's going to come down to, either hung or guilty on a lesser included count 2. I would be surprised if it was not guilty across the board. I think it's possible. That's obviously what I would do. But I would also be surprised if it came back guilty. I guess I'm predicting another hung jury, which I hate to do because it's such a low probability that it happens. But if I had to guess, and people are always like, don't say this or that, or maybe this or maybe that. Like, tell us what you think. It's like, I don't know. I don't sit here and act like I know what's going to happen. So I try to explain what each side's going to argue, what I would do if I was this side, how they can use it in court. That's the point of me. You giving your opinion as a juror is great. Like, this is how you see it. This is how you would vote. This is what you, that's not what I'm here for. And it bothers people and they want me to act like something is set in stone and like I know and I would do X, Y, and Z. That's honestly not how I think when I watch trials. I think when I hear an opening statement, immediately I'm like, what would I do different? Or what did I like about that? Oh, I would have said this, especially in a case like this now where I feel like I know so many of the facts. The first time listening, when I listened to the opening statement, I'm like, what is this case about? Because that's what an opening statement should be. And I'm like, if they don't explain to me what this case is about, they didn't do a good job. When I go in as a juror and I don't know anything about the case, especially the prosecutor, if I still don't know what this is about, I'm like, it's a bad start for you. Your witnesses better be really good. That's kind of how I think about it. Not, where am I at already in the case, or where do I feel like this person's lying? It's always hard for me to do that too. Like, people are so quick to be like, this person's lying. This witness is lying. I don't trust this witness. I don't believe this witness. I generally am like, okay, if this is true, what does that mean? That's kind of how I think about it. I don't know why.
Yeah. The openings were very different in this case too. Lally kind of went through the entire witness list in his, and then, Yannetti comes out with like Karen Reed was framed. It was 2 very, very different approaches. And I found Lally's was, for me, hard to follow. And I know all the, like, I had been knee deep in this and knew all the people in the case and still had a hard time following that. So it was,
it's tough. It was a tough watch.
And I think Jackson's doing the openings this time, right?
Yannetti said he's not opening. I don't know if they said who's opening.
Gotcha. It'll be interesting. It'll be interesting. Well,
all eyes on this trial, that's for sure.
Yeah. Well, I appreciate you coming on with me and taking the time. I know you're a very, very busy man. I'll be looking forward to your recaps. For those of you who are want to watch it live, I'll be streaming live on my new channel with Crime Junkie Jury, and we'll be streaming all day. And then I will be watching Peter's recaps at night to get all the legal perspective.
Wow, the whole streaming world, like nonstop streaming an entire trial, I could literally never do that. I could literally never do that for about 100 reasons. So kudos to you guys that do it and walk through the whole thing. I'm usually listening on 2 or now 3 times speed on YouTube is like a new challenge for me. So I do like it. And dig in. Everybody watch with Brandy. It'll be fun. You can get her opinions as you go in. I'll be recapping them. After every day, I'll probably do dailies when I can throughout the entire trial. But thanks for having me on.
Thank you so much. All right. I will see y'all. It starts tomorrow. So we'll see how long it takes to get a jury set. So I will see y'all all soon.
I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?